welcome to this afternoon's environmental briefing. It's great to see so many familiar names, and also welcome to people who are coming to see us for the first time. We, as a Chambers, hope that you and your loved ones are well. We're down to run till about 5 o'clock, but there are going to be 4 presentations of about 20 minutes each. There will then be a Q&A afterwards. And if you look at the bottom of your screen, you'll see a Q&A box. So you can put questions in the Q&A box. We may have time for all of them, we may not. We'll just have to see how we go, but we will do our best. But we'll do that as a live session. The slides will be available afterwards. If you do need them now because you need to view them and you can't view them through the screen, please contact Deirdre, who's hosting the session, and she will send them to you. You know where the toilets are, you know where to go if there's a fire alarm, and unfortunately we can't host drinks afterwards, but I understand current scientific advice is that drinking after 4:30 during lockdown may well quench your thirst, so we don't discourage that. Now, without further ado, I'm going to move to the first presentation, which is on air quality, and I will be delivering that together with Esther Drabkin-Reiter. Esther joined Chambers as a tenant in October 2019, and she's developing a very strong practice across all of Chambers fields, but in particular in environmental law, and she'll be co-presenting the paper with me. So I'm just going to share my screen there. So there are 3 things we're going to cover. A little bit of comment on the impact of lockdown and the virus, then an update on recent case law, and followed by that, some recent policy developments. We thought it was worth just making a few comments about the impact of lockdown, because I think most of people who work in this field have obviously realized there's an impact. Before I go on, I'd like to thank the lovely Matt Stoling from Isopleth, who has been answering various queries of mine that I've been sending him about practical implications. So thanks, Matt. We've highlighted some points below. Obviously, air pollution levels are falling. It's probably too early to really see exactly what the impact of lockdown has been, and how it will last, obviously, or if it will last when we come out. But we've got, I'm just going to move on to the next slide, because here you see on the right, and this is from a document published by Air Quality Consultants, a graph that compares NOx levels in the period 24th of March to 9th of April with 1st of January to 14th of March this year. So pre-lockdown and post-lockdown, if you like. And you can see quite considerably the blue stretching out to the left, which are percentage reductions, huge reductions in some areas over that period. Some increases further down the screen in a few areas, but generally speaking, significant reductions. So there's obviously been a change. I guess the question for us all is not only how might things carry on, but how will behavioural attitudes change coming out? I mean, one of the things that strikes me is things that we thought were not possible, we now know are possible. I mean, behavioural changes, for example, doing a lot more things online, not travelling unless we need to. And it'll be interesting to see whether regulators, particularly planning authorities, for example, when it comes to imposing conditions or requiring green travel plans, that kind of thing, are now willing to impose stricter requirements, or indeed whether developers are more willing to offer them in what's often been called the new norm. So let's wait and see, but it's interesting. And I think if there is a genuine cultural change in the way people are prepared to work, then we could really see what in the past would seem like more stringent measures, but in the future may seem like quite normal measures being introduced to help air quality. So without further ado, I'm going to move on to some case law and a case law update. So the Shirley case, first of all, there are lots of Shirley cases because Miss Shirley is quite a enthusiastic litigator. This is one of them from last year. I acted in it for Canterbury. And it's a peculiar case procedurally, but it's an interesting case on the substance. So Miss Shirley is a local resident in Canterbury, and the challenge was to a refusal of the Secretary of State to call in a planning application. And that planning application was for major housing development, which the council in its officer's report accepted had the potential to adversely affect air quality. And Canterbury had designated an air quality management area because of nitrogen dioxide exceedances. So the claimant was saying, well, look, Secretary of State, you have obligations under the Air Quality Directive to ensure compliance. Here you've got a circumstance where there is an air quality management area and there's a planning application which it is accepted may have an adverse impact on an area where there are already exceedances. So surely you, Secretary of State, have to, are under an obligation to ensure compliance. So you have to call in the planning application and ensure that controls are imposed on it, or potentially that it's refused, in order to ensure that the objectives of the directive are met. So underlying the challenge then is this idea that where a member state's under an obligation to ensure compliance, then there may be a duty upon the member state to take certain forms of action. Now the challenge failed, and there are two really interrelated points, but interesting points that emerge from it. The first, and it's a really important point, and it's often not clearly understood. The first is that for a specific planning application, the Air Quality Directive does not impose a legal obligation that the decision maker ensures compliance with air quality limit values. So here was a case where the limit values were being breached and the application may make things worse. It had a potential for adverse impacts, but it was held by the court that impacts were simply material planning considerations. In other words, the effect that the development might have had to be taken into account. Weight was for the decision maker. The directive did not mandate a particular outcome. It didn't require, for example, the planning application to be refused. So that's the first point, and that's a really important point. Second point is this, and it kind of explains the first one. The second point is that under the directive, where the member state is in breach of limit values, then there's an obligation to carry out or give effect to an air quality plan, to draw up a plan as prescribed under the directive. And one of the requirements of a plan is that it sets out measures that make the period of exceedance as short as possible. So the exceedance is acknowledged to take place. State's got to adopt a plan, and in that plan, it's got to have measures to make the period of exceedance as short as possible. So it's kind of like a remedial plan, really. It's like a remedial measure. And the importance of that is that what the court said was that that is a bespoke remedy under the directive for breaches of the limit exceedances of the limit values under the directive. And that was another reason why the court said it wasn't necessary for other action to be taken. Once the exceedances had taken place and the plan was in place, that was the bespoke measure, and the directive had nothing further to say on what had to be done. It didn't mean that the member state couldn't do other things, it just meant that the directive didn't require the member state to do other things. So that's that case. So in one sense, it kind of loosens the impact of the directive on individual applications. I would sound this note of caution though. I think it's really important if you're a developer wanting to ensure a kind of a challenge-proof decision, or if you're a planning authority or a regulator wanting to ensure a challenge-proof decision, that even though these issues to do with limit values and exceedances are material considerations, they don't mandate a particular outcome. Nevertheless, I think it's important in the decision-making documents that the purpose of the limit values and the importance of the directive and what its objectives are set out, because there have been lots of instances in other contexts where material considerations have an underlying legal framework, that if the legal framework hasn't been appreciated properly, then the consideration of the material factors has been held not to have been lawfully carried out. So I think it's important that the paper trail for decisions does acknowledge the importance of the directive and what it aims to achieve. Right, the next case is a European court case, Cranest. This again is under the Air Quality Directive, and it concerns monitoring and monitoring location. So Annex 3 of the directive requires that sampling points be cited in such a way as to provide data on the areas where the highest concentrations occur, the areas where the highest concentrations occur for periods that are likely to be significant in relation to the averaging mechanisms under the directive. And this was a challenge to monitoring locations. So it's obviously important because we can all understand the scope that changing monitoring locations may have for suggesting compliance or non-compliance with the directive. So the court took this very seriously, and it started off by saying, look, the obligations in the directive that do with monitoring are very clear and they're very precise, and therefore they're directly effective. So a citizen can rely upon the directive directly in the domestic courts. They then said, look, sampling is really one of the things at the heart of the directive. So it's really important that sampling is carried out lawfully in order to ensure the effectiveness of the directive. So what then happens in the court's judgment is there's kind of a dance between, on the one hand, recognizing the importance of monitoring and monitoring locations being in the right place, but on the other hand, recognizing that the member state must have a discretion in where the monitoring locations are physically placed. And so what the court did was it acknowledged that there was a discretion about where the monitoring locations were, and it acknowledged that the exercise of that discretion would involve technical matters, complex matters, and matters of judgment. But nevertheless, it said that that discretion as to where the monitoring locations were couldn't be exercised in such a way that would undermine the directive. And there's an important passage, it's at paragraph 50 of the judgment, where the court said, sampling points, such a way as to minimize the risk that incidents in which limits are exceeded may go unnoticed. So you've got to, the member states got to limit, I'm pausing there because I think the member states got to limit the chances for exceedances to go unnoticed. So it's a bit like a precautionary approach to the directive. So that's monitoring. The second part of the decision was about averaging. And so a question arose about whether, when you've got monitoring in an area, could you average out the monitoring results across different sampling points in order to change the overall outcome as to whether limit values are being exceeded or not? And what the court said there was, look, the sampling points in a particular area are themselves chosen to be representative of human exposure. So if there is exceedance at a particular monitoring point, that demonstrates an exceedance and an unacceptable exposure to human health. And therefore, it's not acceptable to average out across different sampling points in order to skew the results. It's the results at the particular sampling points that are important. So I think one of the outcomes of this case may well be, particularly the approach that was taken to discretion and then how discretion was limited by the purposes of the directive, may well be challenges that are brought which run along the lines of either claimant accept that there's a discretion here, but look what the court has said in cases like Cranest, it's actually a limited discretion, and the domestic court is entitled to, and in fact under an obligation to, see whether the objectives of the directive are being lawfully discharged. So let's wait and see what happens there. There was a point on this case raised in the recent Heathrow litigation, but it didn't get anywhere. But this might be one of those areas that spawns further argument. So with that, I'm going to hand over to Esther. So if I could invite Esther to turn on her camera and her microphone, and I will control the slides, and Esther will continue with the presentation. Thank you.
Thank you, James. If you could just move to the next slide, that would be great. So Gladman Developments are another prolific litigator. This is one of many cases which they were involved with in 2019. And this one, which went to the Court of Appeal, was a challenge to an inspector's decision following a planning inquiry to refuse planning permission for a housing development in Newington in Kent on, among other things, air quality grounds. And the Campaign for the Protection of Rural England in Kent was a Rule 6 party at that inquiry and relied on its own evidence of air quality, which the inspector took into account and relied on. The challenge was dismissed in the High Court and then went to the Court of Appeal, which identified issues concerning the application of the High Court decision in Client Earth No. 2 in 2016 and the approach the inspector had taken to air quality mitigation. The appeal was dismissed by the Court of Appeal, essentially on classic planning grounds that will be familiar to all those of you dealing with planning cases, that these were matters of planning judgment for the inspector and that his conclusions were not irrational. However, there are a number of points of wider interest in the air quality context. So the first is that the court found that it was open to an inspector to find that development would have an adverse impact on air quality and that this would be a sufficient reason for refusing planning permission, even in the light of the EU law duty to produce an air quality plan under the directive. And there was no suggestion that that duty, as emphasised in the Client Earth case, to produce an air quality plan and to comply with the limit values as quickly as possible, meant that planning decision makers should presume that the UK would become compliant with the limit values in the near future. So tying back to what James said about Shirley, this case again emphasised that there is no specific duty under the Air Quality Directive to take particular action in relation to planning consents on the basis of air quality. It will always depend on the particular circumstances of the case and will be a matter of planning judgment. The second point of interest relates to what is now paragraph 183 of the MPPF, which provides that the focus of planning policies and decisions should be on whether the proposed development is an acceptable use of land, rather than the control of processes or emissions where these are subject to separate pollution control regimes. And planning decisions should assume that those regimes will operate effectively. So in this case, the appellant argued that that paragraph should be applied to the regimes under the Air Quality Directive, such that the inspector should have assumed that the air quality plan measures would operate effectively to remove any concerns about air quality. This argument was rejected by both the High Court and the Court of Appeal, that considered that the duties under the Air Quality Directive were not a parallel consenting regime to which paragraph 183 would apply, because there's no separate licensing or permitting decision that would address the specific air quality impacts of a proposed development. Those impacts would only be considered in the decision to grant or refuse planning permission. The third point is a more general point in the planning context about what conditions inspectors should apply or decision makers should apply. And the Court of Appeal rejected an argument from the appellant that the inspector should have considered imposing a condition that none of the parties had raised at the inquiry, namely that development should not commence until a satisfactory air quality mitigation scheme is in place. And the court emphasised that there's no general statutory or policy requirement that someone taking a planning decision must always seek to make an unacceptable planning proposal acceptable by imposing a condition to essentially give the developer time to come up with an acceptable scheme. It's for the parties to raise such a condition if they wish to rely on it later. Next slide, please, James. So the next case, another decision of the Court of Appeal, is the case of Kenyon. This was a challenge to Wakefield Council's decision that no environmental impact assessment was required for a new housing development of 150 homes in West Yorkshire. This is another decision in which the breadth of the decision maker's planning judgment has been emphasised by both the High Court and the Court of Appeal. And the Court of Appeal was quite critical, in fact, of appeals brought in this context, stating that it was difficult to discern any substantial point of principle in the case, and wondering whether the most important point to arise from the case was the need to ensure that appeals in cases of this kind do not become another weary trot around a well-worn course. So it emphasises perhaps the need to consider how to frame any environmental impact assessment challenges quite carefully. It raises a couple of points of wider interest in the air quality context. Again, the finding that air quality duties will not necessarily lead to an inevitable result in planning decision making. The court held that it was not possible to argue that the mere fact of proximity of a housing development to an air quality management area and the resulting increase in traffic movements means that there will inevitably be likely significant effects on the environment. So merely because there was a likely effect on an air quality management area did not mean that those effects would be significant. And it was also clearly open to the decision maker and a matter of planning judgment to find that the limited site area of the development and its scale meant that increased traffic impacts will not have significant effects. The court also made some comments regarding the detail of reasoning necessary for environmental impact assessment screening decisions, noting that it wasn't necessary for a local planning authority to set out all the information and statistics which might be relevant to the question of air pollution, and which led them to conclude that there would be no likely significant effect. For example, as I put on the slide there, published data on trip frequency, standard emissions, and exceedances. A local planning authority will be well aware of such information and can be assumed to have taken it into account. Next slide, please, James. So I'm now just going to cover a couple of policy developments, and the main one here is the issuing of the new Clean Air Zone framework in February this year, an update from the 2017 document. Clean air zones are a new policy measure which is being adopted by the government and implemented in various towns and cities across the country, designated areas where special measures are being put in place to improve air quality. And they are a policy rather than a statutory designation. They're not provided for in statute, although where a decision is taken to implement a charging clean air zone, those charging powers are provided for under Part 3 of the Transport Act 2000. So the February 2020 Clean Air Zone framework only applies to England. There's a separate framework for Wales, which was first issued in 2019. And there are a number of points to note from the 2020 update. So the government has put in place a clear incentive for implementing clean air zones, as it's provided that when bidding for central government funding, where air quality is one of the stated assessment criteria, a clean air zone which is in line with the framework will give an additional advantage to any local authority which is seeking to bid for that funding. The framework now sets out detailed guidance on the minimum requirements of any clean air zone, whether that's a non-charging or a charging clean air zone. Mostly these requirements are about promoting awareness of clean air zones and encouraging local authorities to lead the way in good practice in improving air quality. And they include things like having signs in place along major access routes to clearly delineate the zone, being identified in local strategies such as local plans and local transport plans, providing active support for ultra-low emission vehicle take-up through facilitating their use by providing, for example, charging points, following clean air principles in local authorities' own vehicle operations, as well as public transport and taxi and private hire services in their area, and supporting healthy, active travel and raising awareness about air quality issues. For charging clean air zones, local authorities need to decide which class of vehicles they wish to charge. Vehicles have been grouped into charges in the clean air zone framework depending on how polluting they are. And a local authority can decide to the extent of the vehicles they wish to include, whether this is going to include, for example, vans and minibuses and private cars and motorcycles, as well as public transport vehicles and private hire vehicles. The various classes are specified now in the Clean Air Zone framework at Annex A, the new framework also indicates that in future, the charge levels will be published in that document, and also recommended signs, but they're not included in it yet. And then I've also mentioned, as a final point on this slide, that there's been an update to the planning practice guidance on air quality. This is the first update since the PPG was issued in 2014. It's just there for reference. There is more detail in it now, but haven't been any real substantive changes. So that concludes our presentation. Very well, happy to take any questions at the end if you include them in the Q&A box. Thank you.
Thank you very much, Esther. Now, our next talk is going to be given by Charles Streeten. It's on the Green Deal. Charles has a very strong reputation across the board, but particularly in court work. He's got over 30 reported cases covering the High Court, Court of Appeal and Supreme Court. He does a lot of environmental work. He was on the claimant's side in the Shirley case that I just mentioned. He's got particular expertise in regulation and sanctions, and of particular relevance to the talk he's about to give. He is the barrister advising the government on sanctions decisions relating to the Green Deal. So, Charles, over to you. Thank you.
Thank you very much, James. Yes, I'm talking about the Green Deal today, which has been a subject close to my heart of late because I've been advising the government on it, but mostly it will be a dim and distant memory for people because, if we get the first slide, it was introduced back in 2012 and it ceased to function in 2015. So what we're really dealing with these days is the fallout from the Green Deal rather than the operation of the deal itself. The idea behind the Green Deal was that individuals should have a mechanism of financing green technology at their property, and in particular there was take up in relation to photovoltaic panels and other energy saving measures. The way that it was designed to work was that Green Deal plans would be issued by what were called Green Deal providers that would essentially be a credit agreement under which the individual paid back the cost of the green tech that they were lent through their property's energy bills. The way in which the system was designed to work had 4 stages. Firstly, what would happen is a government registered assessor would come round to the property where somebody was looking to install some green tech, and they would assess the property to see what improvements could be made. And it was anything ranging from putting in cavity wall insulation to using proper green renewable technology, energy generating measures like photovoltaic panels or wind generation. There'd be an assessment as to the cost benefit of that, and having done that, a variety of options would be provided, a variety of different costs, and what the savings were predicted to be on the basis of government predictions for each of those measures for that type of property. There'd then be an opportunity to enter into the plan. That would be a contract between the homeowner and the Green Deal provider, and they essentially would facilitate a financial arrangement between the individual and the Green Deal finance company, which was a government-backed lender who would provide the money for the measure. The measures would then be installed and people would pay that back through their electricity bill. Something kind of interesting, very different about the scheme was that that was attached to the property, not to the individual. So it was a bit like a mortgage. It ran with the land, and when you sell your house on, if it has a Green Deal plan, then there are a series of disclosure obligations because the next person is going to be tied into the scheme. There are a couple of safety features included to try and avoid problems, or how successful that was we'll see in a bit. The first of those was that everyone who was involved in the scheme had to be quality assured, certified by a body and registered with the government. The second was that there was a code of practice published by the government under a statutory requirement. So it was a statutory policy essentially on what people who were involved in the Green Deal had to do, and non-compliance with that had sanctions consequences, as we'll see. And then finally, and perhaps most importantly, there was what was called the golden rule, which was that you could not enter into a Green Deal plan unless the estimated savings would exceed the cost of the green technology being installed. At this point, I just want to pause and deal with something slightly outside the Green Deal, which is what's known as a feed-in tariff. That's where if you generate electricity at your home, or indeed at your business, you're able to sell that back to the grid if it's generated through a renewable means, so through photovoltaic panels, wind turbines, hydroelectric or anaerobic digestion. And that's a different contract, but you'd often see it entered into at the same time as a Green Deal plan. So someone would use the Green Deal to borrow money, say to install a wind turbine in the field next to their house, or to put photovoltaic panels on their roof. And then they'd also sell the electricity that they generated from that on to the energy provider, ideally as an additional way of paying for the cost-saving measure. It was a heavily regulated financial system. It was regulated under the Energy Act 2011 and also under a specific set of delegated legislation, the Green Deal Framework Disclosure, Acknowledgement and Redress Regulations. As I've already said, there was a statutory code of practice, and under the regulations, breaches of the code of practice could result in pretty severe sanctions from the Secretary of State, ranging from cancellation of the plan, which essentially means the debt is cancelled, or a financial penalty, down to a compliance notice, which said you've done this wrong, don't do it again in future. Any sanction was subject to an overarching proportionality requirement. So if the Secretary of State imposes a sanction, that sanction has to be proportionate to the breach. In terms of how the sanctions process works, and this is what's most relevant for the litigation that's ongoing at the moment, Regulation 52 requires an eligible complaint for a sanction to be imposed by the Secretary of State. So somebody has to send something to the Secretary of State saying there is a problem here. That has to then be investigated. Following the investigation, the Secretary of State under Regulation 72 has to issue what's called an intention notice, saying this is the sanction I intend to impose. And in light of that, the parties then make representations and a decision notice is issued. If a sanction is imposed, it's a sanctions notice saying here is the sanction that we impose. If not, it's a decision notice saying no sanction is imposed. And then there's an appeal to the first tier tribunal in circumstances where that sanction is disputed. The problems that have arisen have largely been from one or two very large Green Deal providers, the most famous of which has I think appeared on a number of daytime television programs, is Home Energy and Lifestyle Management, as it was called. And that sold 4,263 different photovoltaic panel sets to various people, often elderly and perhaps rather more vulnerable people than you might have expected for a demographic of a big company like that. And what it also did was it entered into the loans and then immediately assigned the benefits of those loans to a company called Green Deal Framework Company Limited in return for a cash sum. So it essentially divested itself of any of the risk involved in the loan. It turned out that its practices were, to say the least, non-compliant with the Code of Practice. It was fined £200,000 by the Information Commissioner in 2015. There was a further fine by DEC, as it then was, the Department for Energy and Climate Change, the same year. And as a result of the nature of its business, it went into liquidation in 2016. All of the loans that it had given out were held by a company called Green Deal Framework Company Assets, which was a subsidiary of GDFC Limited. And that was sold to a number of finance funds, so Greenstone Finance, Arian Capital Markets, and Honeycomb in 2017. So we're now in a situation where the people who have the benefit of the loans had absolutely nothing to do with the loans being issued, and the person who issued the loans in breach of the Code of Practice no longer exists. As a result of that, a number of sanctions decisions which have been issued by the Secretary of State have sought to work out what a proportionate sanction to impose on the beneficiary of the loan is in circumstances where they weren't the individual who breached the Code of Practice. And there have been 3 tribunal cases on this so far. Mason and Leach, both of which I was involved with, and Tibbs, which was dealt with solely on the papers. Those are the 3 decisions so far. And I think it's interesting to see what the tribunal has said in those cases, because Leach, which was the first case, clearly troubled the tribunal, and indeed the tribunal overturned the Secretary of State's sanctions decision on the basis that it wasn't harsh enough against the beneficiary of the loan. What the Secretary of State had done was to say, well, Mrs. Leach, the individual in this case, did at least have all of the contractual documentation in front of her. She seemed to understand the nature of what she was entering into, even if the way in which it was sold to her wasn't in accordance with the code of practice. And she has, as a result of that, entered into a bad plan which breaches the golden rule. So what we'll do is reduce the sanction, or reduce the plan to the level Mrs. Leach seemed to think she was entering into, essentially a level which will result in her making energy savings. She challenged that and said, no, I don't want to have any plan at all. And when it went to the first tier tribunal, the Chamber President said, I agree with the Secretary of State that there are breaches of the Code of Practice. In fact, I agree that those are severe breaches and have resulted in substantive loss. In those circumstances, I don't agree with the Secretary of State that reduction sanction as opposed to cancellation is appropriate. In fact, I would impose a different sanction from the Secretary of State because even if all of the documentation was, as you see at the bottom of this slide, strictly formally compliant in contractual terms, it wasn't, in my view, right for these people to be bamboozled, that's the word that the tribunal uses. And in light of that, I think the Secretary of State needs to think again about what a proportionate sanction is. So that's where we are today. The matter's been returned to the Secretary of State. There will be further consideration of what an appropriate sanction is, and very possibly further litigation, because you can well see that the interests of those who hold the benefit of the loans, which would be cancelled if that is the sanction imposed, and the interests of the consumers who were unfairly sold to are essentially irreconcilable, and the balancing exercise in imposing a sanction between the two means that I predict in the future further litigation on this point. So that's really been my whistle-stop tour of the Green Deal, and as I say, I'm happy to answer questions at the end. I'm hoping James is going to jump in now, but he doesn't seem to be reappearing. There he is. Right, James, that's really done in record time.
Thank you very much. Thank you very much, Charles. Well, look, let's move on then to the next topic. It's another kind of cutting edge and current topic. It's about climate change and net zero. And there are two speakers. Ned Westaway, who's been practicing for at least 10 years now at the bar. He's appeared in the Supreme Court, the Court of Appeal, the High Court. He's on the government's B panel. He does a lot of, a broad range of work, but including major infrastructure. Recent cases include the Stonehenge DCO, the Drax Power Challenge, which was heard last week. And co-presenting with him is Merrow Golden. She's a junior barrister. She specializes in planning and environmental law. She regularly advises on environmental matters, and some of her current cases, again, include the Drax litigation, some current challenges to HS2 and the Whitehaven coal mine proposal. She's rated among the top juniors by Planning Magazine in the last 2 years, and she's admitted as an attorney to the New York State Bar. So thank you very much. If I could ask you, please, Ned and Merrow, to share your screen and start your presentation. Thank you.
Thank you, James. Just while I'm doing that, share. Excellent. Brilliant. Thank you. So this is being brought to you from a combination of North London and Bude in Cornwall. And I think that one of the buzzwords in climate change is pathways. What is the pathway? It was to 80%. Now, what's the pathway to net zero? The pathway for us is a little bit easier. It's what's the pathway to getting to round about 4 o'clock or just after 4 o'clock. And it is that I will spend about 8 or 9 minutes, I hope, on some statutory context discussing the current position a little bit and some of the tensions that I think arise in climate change litigation. And then Merrow is going to provide a whistle-stop tour through 4 very current and recent cases. Plan B Earth, which is the Heathrow case, was pretty recent, although it feels like a world ago, on the 27th of February. And then since then, there's been further cases and hearings. Packham was the case about HS2. Client Earth is the Drax case, and that was heard last week. And Merrow was junior counsel for the claimant, I was junior counsel for the defendant. And Bennett is another one, but one of quite a number that's sitting in a pipeline, either at pre-action stage or, as with Bennett, waiting possibly for a hearing later this year. And that's the coal extraction case in Cumbria. So lots of action, and I think the Heathrow judgment has only incited further action. But I want to start pretty briefly by going back to the beginning with the Climate Change Act. Of course, that wasn't when climate change started, but it was at its time a pretty radical piece of legislation. And we can focus on the target, and the target is clearly one of the very important things about the Climate Change Act, the headline points in section 1. But there's 2 other elements of it that are very important. First, the budgeting periods. So the target is informed and supported by these 5-year rotating budgets. And then secondly, the Committee on Climate Change, which was established in the latter part of the Climate Change Act. And the Committee on Climate Change really give the policy and scientific discipline to all government action in this area. And they're a mandatory consultee, and they can trigger action in Parliament because they lay reports before Parliament. There's 2 possibly caveats, but I think important perspectives to have when one's looking at the Climate Change Act, and perhaps to ask why it is that there hasn't been much litigation on it yet. The first is it's not quite constitutional legislation, but it is, I think, embedded legislation. The targets and the budgets, once they're set, can only be changed if there's significant developments in scientific knowledge or in European or international law and policy. And that indeed was what caused or what was used to justify the 2019 order that set net zero. And I don't know, it might be quite small there, but you can see where I'm circling that the Secretary of State considered there had been significant developments in scientific knowledge. So the net zero order was founded upon what was said to be very significant changes. The second point is how the Climate Change Act itself anticipates its own policing. And it is, if one looks at it, enforced not by any kind of sanction, but by way of reports and statements that are made to Parliament, and perhaps rather weakly, or you might say rather innovatively. The sanction is that where the budget or the target is not met, the statement of the minister must explain to Parliament why it's not been met. So actually, while we talk about net zero by 2050, the actual key date is May 2052, when the 2050 report, presumably telling us that we've reached net zero, will come in. This is one of the many pieces of information produced by the Committee on Climate Change, and I think just gives graphically a nice demonstration of the scale of this challenge. I want just briefly again to look at how I think the Climate Change Act and climate change in particular is gaining a lot of traction. It's not just legal, it's political as well. The number of court cases is in itself quite interesting. If you do the not quite scientific approach of searching Westlaw for climate change cases, and you search under the subject climate change, you get just 19 results, and a number of those relate to financial mechanisms or business mechanisms in some way. Just 8 of them are challenges where a climate change commitment in some way, shape or form is relied upon. And most of those are in the last 2 years. So there is a spike, and perhaps there's no surprise at all, because we can see with Heathrow and Packham, 2 cases already this year, and as I say, there's others in the pipeline. And I think there's a really nice website there which gives a link to cases across the world. It reflects a trend across the world. The question is it a trend that's going to lead to a sustainable number of climate change cases that are actually successful, or will it be a spike that dies away? Climate change is obviously recognised more and more in policy, and that's a way that it can then find purchase in decision making and law. Declarations of climate emergency are interesting. If we wind back about a year, they were very fashionable politically. It was, I think, almost every day there were councils making declarations. The UK Parliament did, a little bit after actually it had already been done in Wales and in Scotland. And I've given a reference there to a planning appeal decision where an inspector, was a single wind turbine that was an issue, but an inspector found there was a conflict with the NPPF, or a tension with the NPPF, but among other things, placed some important reliance upon North Norfolk District Council's declaration of climate emergency of late April last year. So these declarations aren't meaningless, and certainly can be relied upon as having some material import in decision making. And then lastly, recognition in the courts. We've seen that, of course, in the Heathrow case. McLennan is an interesting case to look at, just to see how the courts will treat climate change on its own as a significant material consideration in planning, certainly something that cannot be ignored. The facts in that case are slightly unusual. Medway Council were asked to grant permission, granted permission for an extension where the extension would shade someone's solar panels. They said that the shading, or the potential shading, because it hadn't been entirely established, of the solar panels was not a material consideration because it was purely a private interest. And the court said, you can't do that. Climate change is now a factor that's written into our planning legislation. That's section 19(1)(a) of the 2004 Act. And a council cannot lawfully treat it as immaterial. Of course, they could have given it little weight had they wanted to, but they had to grapple with it. Then lastly, a few tensions. And in a way, these are all expressions of the same thing. I've set them out as policy level versus decision-making level, regulation versus market, precaution versus prediction. And one finds these, I think, arising certainly in the case law we've had so far. At the Drax hearing, it was interesting. The debate was focusing in part upon the meaning of policy EN1, government's overarching policy for energy infrastructure. And an argument that was made before the judge, and the judge will now be going away to think about, was that the policy dealt with climate change. There was nothing left to do at the decision-making stage. It's addressed in the policy. It's addressed by effectively saying market mechanisms, in particular the emissions trading system, are the way that this will be, that climate change will be taken into account, plus favouring of carbon capture readiness and a few other elements of the technologies that are favoured or disfavoured. And it wasn't something that needed to be separately dealt with. Precaution versus prediction. One aspect, I think, of the Heathrow case that's very interesting is actually not the CO2 emissions, but what the Court of Appeal said on non-CO2 emissions. And it's worth looking at how the Court of Appeal brought in the precautionary principle by saying that it's not enough to say that it's difficult or even impossible to properly assess these non-CO2 emissions. You have to look at them. You have to somehow take them into account. And those three tensions, 1, 2, and 3 on that slide, I think all really wrapped up in the term polycentricity, which is the term favoured of Liz Fisher, the Professor of Environmental Law at Oxford, and derives from Lon Fuller. And I'll finish on a sort of picture slide. The polycentricity is effectively a problem that has many different angles, many different layers. So you cannot meddle with one or resolve one without causing impacts on another. And Lon Fuller says this is like a spider web. If you say pull one piece of the web, which might be in the energy sector, you put more pressure or less pressure on another piece of the web that might be the transport sector. If you change that, you put more pressure on other areas. And I don't think there is a problem that humanity faces at the moment that's not that's more polycentric than climate change. It's something that makes it conceptually difficult for lawyers. It's something that makes it particularly challenging, and it might be one of the reasons why, at least to date, there's not been a great deal of litigation on it. I think with net zero, there's some real opportunities for litigation, but I still think the polycentricity problem is one that lawyers in this area need to grapple with. So with that, I will mute myself and hopefully pass over to Merrow, but I'll remain in control of these slides. That should work.
Great. Well, thank you very much, Ned. And as Ned said, this is going to be, I'm afraid, a whistle-stop tour of 4 cases in sort of 10 minutes. So there's no way, I'm afraid, I can really do them justice. But to start with Heathrow, and as most of you probably already know, this was a challenge to the designation of the airport's national policy statement. So if maybe we'd move to the next slide, and that will have many thanks. So the context here is relevant. At the time of designating the airport's NPS, the Climate Change Act target was a reduction of 80% from 1990 levels. And so we hadn't actually got to the net zero target yet that we have now. And that 80% target had been based on what was then at the time the limit on global temperature increases of 2 degrees. Now, by contrast, the Paris Agreement went further and enshrined a commitment to restricting global temperature increases to well below 2 degrees and really to pursue efforts to limit them to 1.5 degrees. What was interesting about Heathrow is the Secretary of State was very clear actually in saying that in designating the NPS, he did not have regard to the Paris Agreement, did not take it into account. He only had regard to the Climate Change Act target, that 80% reduction. So the court was actually faced with quite a crisp question really, which was the Secretary of State under a legal obligation to take the Paris Agreement into account? And I'm focusing really on that one point. As Ned mentioned, there were many other grounds as well, and Ned mentioned the point about the non-CO2 emissions. But just looking at this question about taking the Paris Agreement into account, if we move to the next slide, you'll see that, thank you Ned, you'll see that Plan B framed their case on Section 5.8 of the Planning Act, and it's set out there in the slide, and their case is really quite simple. They say that the Paris Agreement was part of a government policy on climate change, and so under Section 5.8, you can see it there, that needed to be taken into account. And on the next slide, you'll see that the Court of Appeal agreed with them on that, to put it simply. If we, and I'm aware you're going to get these slides, and so I'm sort of moving through quite quickly, but if we move to Friends of the Earth's case, they focused on Section 10 of the Planning Act, and really Friends of the Earth argued here that if you look at the language there in Section 10, particularly Section 10.3, that the Secretary of State had erred by failing to ask himself whether he could take the Paris Agreement into account in relation to exercising this duty. And if he had asked himself that question, then the only actually rational conclusion he could have come to was that it was so obviously material to the point that he needed to consider it. And on the next slide, you will see that the Court of Appeal agreed with that as well. So sort of two ways to get to the same answer here. So that's a very short coverage of that one issue really in Heathrow. If we move on to HS2 and the Packham case, this was a recent case brought by Chris Packham, who you might know off the telly, from the Really Wild show, and this was a challenge to the government's recent decision to press ahead with HS2. Many of you will be aware that back in August last year, the government decided to reconsider whether, and if so, how it would pursue HS2, particularly in light of rising costs. And a review was commissioned, chaired by Douglas Oakervey, and that review resulted in a report recommending to the government that on balance it should pursue with the project, and the government followed suit essentially and gave HS2 the green signal. So this was a judicial review of that decision, and there were a number of grounds. I'm just going to focus on the climate change point. And there are a couple of extracts. Oh, sorry, Ned, if we could just go back to the last slide. There are a couple of extracts on the slide from the report, thanks, that you'll see there. And you'll see from those extracts that the report did look at emissions in relation to the project, did also look specifically at the net zero target, highlighted that. You had a situation here with HS2 where there was a construction phase for the project that was in the short term going to be very bad for emissions, and that was going to be followed subsequently by the operational phase, which was not only not going to be so bad, but it was said in the report it may even contribute to tackling climate change, but that's the late operational phase. And the report also noted that overall, in the whole lifespan of the project, construction and operation phases combined, that it was likely to be carbon neutral overall. So far so good. You might say, what was the claimant's complaint here? But if we turn to the next slide, you will see that the claimant's argument was that the government had, notwithstanding all of that, had still failed to take into account how the construction of HS2 was going to impact on the Paris Agreement requirements. And that was an obviously material consideration in the circumstances. And recognising that the net zero target, which is just set in 2050, was a key instrument. It is a key instrument to getting us to complying with Paris and the global increases in temperature. But Paris is not just about the net zero target, it's also about the road to get you to net zero. And in fact, net zero is really a means to an end, which is to keep global temperature increases below a certain level. Crucially, when looking at that, cumulative emissions are key, they're critical. So it was in that context that the claimant was saying with a project like HS2, and you can imagine there's quite a few projects that could be similar, where you've got a short-term negative impact on emissions followed by a different phase. Where you've got that short-term negative impact on emissions, it is necessary to consider how those pre-2050 emissions are going to impact and undermine the Paris objectives. And on a domestic scale, as Ned mentioned, you have these 5-yearly carbon budgets being put in place as sort of your stepping stones to get you to that net zero point. And the Committee on Climate Change is actually at current is saying we're not on track to getting to our 4th carbon budget, which would be for the years 2023 to 2027, which is exactly the same period in which HS2 construction phases will be being carried out. So that was the point really by the claimant, that you needed to have regard to all of that. You'll see on the next slide that unfortunately the Divisional Court was not with us on that point, and I'm not going to go through all of that now, but it is on the slide there. But do note that appeal has been lodged, including on this ground, so watch that space. I'm going to now move on in light of time to the Drax case, which Ned has already mentioned, and I should also note that Mark Westmoreland Smith, who's also speaking this afternoon, was also involved in the matter as well as junior counsel for the interested party. And the hearing was indeed last week and was done remotely, and I speak for myself when I say I think it went relatively smoothly in that regard. So moving to the facts though to begin with, for those who don't know, it relates to the grant of development consent for a large gas-fired generating plant in North Yorkshire, and you can see that on the applicant's own estimates, this was going to result in a net increase in greenhouse gas emissions of 90%, and it was accepted on all sides that the impacts on emissions were going to be a significant adverse impact of the development. It's also quite an interesting case because it was a case where you had the Secretary of State going against the recommendations of her examining panel, who had actually recommended refusal of the project. So there were a number of points of disagreement between the Secretary of State and the examining panel on interpreting policy in the energy MPSs. If we can move to the next slide though, I just wanted to focus, I mean, there are a number of grounds in this case and a number of them related to climate change, so I can't go through them all unfortunately, but I wanted to just highlight a few points. One is that a key issue during the hearing, as Ned sort of touched on, was the extent to which the energy MPSs, and it's EN1 and EN2, the extent to which they allowed for GHGs and climate change impacts to be a relevant consideration when determining whether or not to grant consent for an individual project. And I've just included one of the key paragraphs from EN1 in the slide, so you can see that at your leisure. But I would emphasise that the first underlined sentence here, and that was relied on by the interested party to say that greenhouse gas emissions are actually not a material consideration when it comes to that individual decision making on an individual project. And as Ned mentioned, the point being that this has all been covered elsewhere in the policy, with emphasis being placed on the emissions trading scheme, for example. Client Earth was arguing that this statement was really a point of generality. It did not take greenhouse gas emissions off the table for an individual assessment of an individual project. Moreover, if it were to do so, that would actually be contrary to the EIA regime, whereby a significant adverse impact must somehow be able to factor into the decision-making process. So that's one point. And the other point I just wanted to touch on was the procedural fairness point, because an interesting timing issue with this case was that the net zero target was brought into force after the close of the examination. And both the examining panel and the Secretary of State agreed that it was an important and relevant consideration. Drax, the interested party, and the applicant made submissions post-examination on the point, on the impacts of that change. And Client Earth did not see those submissions until the decision letter was released. So we put a point for Client Earth on procedural fairness grounds that the Secretary of State, she was going to consider the submissions made by Drax. She was only really going to hear half the story, and that would not be fair. And there was a debate about whether she had considered those submissions or not. But interestingly, Mr. Justice Holgate, during the hearing, it was put forward there may be a separate ground here, procedural fairness, whereby the Secretary of State, the question being whether she was under a freestanding duty to consult all interested parties on the impact of that change. So Client Earth were only happy to amend their pleadings to encompass that point as well, and we'll have to wait and see what the judgment says on all of that, but it's definitely one to watch. And then I'm conscious of time, I might have even run out of time, but very quickly, I'm going to just note really the case of Bennett. This relates to the Whitehaven coal mine in Cumbria, and it's the case that's been granted permission on all grounds by Mrs. Justice Lang. The facts are set out there. It's for a new underground metallurgical coal mine. The permission would be for a permission for 50 years continuous coal mining operations. And I think what's interesting here is the council has argued that the emissions relating to the operation of the mine itself, essentially the operation of the mine itself would be broadly carbon neutral. And they've argued that on the basis of what I would term a production substitution point, which is that they say that the extraction and production of this particular type of coal in Cumbria, in Whitehaven, would essentially lead to reductions in the extraction and processing of an equivalent amount of coal elsewhere in the world. So aside from the fact that the claimant has argued that there was insufficient or a lack of any evidential basis for that conclusion, I just wanted to note two other points that may be of interest from this case. One is, if we could just go to the next slide, it's on the EIA ground, and the claimant has argued that an assessment of the emissions associated with operating this mine needed to be included in the EIA, in the environmental statement. And if the applicant was relying on a production substitution type argument to say this is really going to be carbon neutral, then it needed to set that all out in the statement itself. So that's one point. The second point, the last point I just wanted to touch on relates to net zero, and a similar point to some extent was raised as well in the Drax hearing. And the argument is this, that when granting consent for a development that's going to have emissions beyond 2050 or 2050 and beyond, and here with Whitehaven, this development would be, the permission we're looking at would be for 50 years. So we're going on to 2070. When in that situation, the decision maker needs to have regard to the fact that as of 2050, all ongoing emissions will have to be offset or otherwise mitigated elsewhere, because we have to be net zero. So whilst it's not possible for anyone to say really that a grant of consent for a particular development is going to result in a breach of the net zero target, because you can only really see whether that's happened once you get to 2050. The point here is that being argued is that it's irrational. It would nonetheless be irrational to ignore that saying yes to this development is going to make it that much harder for you to get to 2050, and is going to require offsetting or mitigation elsewhere. And the point being, you needed, as the decision maker, to have due regard to that. So that's one of the points that it'll be interesting to see how the courts deal with all of that. But I'm probably way over my time now, so I'm going to wrap up and just reiterate that if anyone has any questions, please do. We'll take questions at the end, so please do add them to the Q&A box that's, I think, at the bottom of the screen. And I'm going to mute to myself and turn off my screen.
Thank you, both of you. Absolutely fascinating, all of that. Absolutely fascinating how climate change and those issues is really now starting to come to the fore and becoming more kind of harder-edged questions. Can I remind everyone, we do have a Q&A box at the bottom of the screen. It's currently empty. We very much would welcome some questions. So if you do have anything to raise, please do so, and we can deal with it at the end. Okay, finally now we have a case law update that's being delivered jointly by Mark Westmoreland Smith and Andrew Fraser-Urquhart. Mark and I have worked successfully on a number of cases, a range of litigation and advisory work. He's got a thriving environmental practice. He was also involved in the Drax case and in another case, which I think he's going to be touching on in his talk. Andrew Fraser-Urquhart's listed as a leading silk in James & Partners. He's also listed as one of the leading silks in Planning Magazine. His practice focuses on a range of issues, but with a particular emphasis on large infrastructure and redevelopment schemes, particularly those with a strong environmental aspects to them. So over to you now, please, Mark and Andrew, if I could invite you to share your screen, please. Thank you.
Thanks, James. So as James has mentioned, Andrew and I are going to provide a case law update. We're going to do that in two parts. I'm going to go first, and I'm going to deal with two cases, Kenyon, and Esther's already mentioned Kenyon, but she's dealt with air quality matters and reasons, and I'm going to look at some other aspects. And then at the end, I'm going to take a very quick look at the Repsol case, which is in relation to the EU ETS trading scheme. And Andrew is then going to look at the recent Stansted case. So to Kenyon. Kenyon is an interesting case. I think it's a good case to look at because it serves as a reminder of both some general points in relation to admin law, as well as providing a helpful summary on EIA screening. The facts aren't essential to the points that I want to draw from the case, but at the heart of it was a proposal, modest proposal, for 150 houses on a disused sports complex. And the claimant applied for a judicial review of a direction issued by the Secretary of State that the proposed development was not EIA development. Incidentally, this case would not make a good advert for the planning system. The original application was made in 2008. It's involved 3 judicial reviews, a Court of Appeal hearing in March of this year. So it's not an example of something moving swiftly through the system. I set out there the grounds as originally pleaded. It was the first of those that made it through to the Court of Appeal, and only that ground, and only partially. It related purely to air quality by the time it reached the Court of Appeal. I want to give you 6 public law takeaways, and then I'm going to give you 4 takeaways in relation to EIA, and I'm going to address each of those in turn. So the first public law takeaway is this. Judicial review is limited to legal grounds alone, and the courts will be alert to attempts to challenge merits by the back door. Now, it's almost embarrassing to raise that, such is its trite nature. It's Admin 101. But I mention it because the Court of Appeal felt the need to reiterate the position. And I just set out there paragraph 2 of the judgment, which I think indicates the court's frustration with the case. So the first point, it's a golden oldie, leave the merits alone on legal review. The second takeaway is do not seek to rely on documents that were not before the decision maker. This is a basic principle, because it's a basic principle of public law, that it's a legal review process. That means, generally speaking, such documents are not relevant. And in paragraph 28 of the judgment, and the underlying text is that which I emphasize, the judge said, taken at its highest, such an approach undermines the entire process of judicial review. It runs the risk that the court will be asked to conduct a kind of rolling review in which nothing is ever finalized or settled. And it does not matter what information was available at the time the decision was taken. This serves only to encourage the all too prevalent attitude that in judicial review applications, it's always possible to have another go. And the judge made it quite clear that for these reasons, he simply ignored documents that weren't in existence or before the decision maker at the time of the screening decision. The third takeaway is avoid challenge creep. The judge noted that whilst in the court below a single ground had permission, the submissions ranged much more widely than that. He described it as challenge creep, and he said it continued on appeal, noting that a single ground got permission to appeal to the Court of Appeal, and yet the grounds of appeal raised 5 individual arguments. So whilst the judge did go on to address all of those arguments, he made clear his discontent and said at paragraph 41 that his observations might be thought to be sufficient to dismiss this appeal outright. So that's a stern warning to avoid challenge creep. And it brings to mind a related point that came up in the Drax appeal last week, in which Client Earth were taking a couple of points that hadn't been taken before the examining authority, and that brought alive the issue of the extent to which new issues can be ventilated on review. And a case that deals with that is Distinctive Properties. It's a 2015 decision of Mr. Justice Holgate, in which he said that whilst it's not impossible in review proceedings to raise a point for the first time, the general principle is that it should not be allowed where the point would have required further fact-finding or investigation by the decision maker. The fourth point is again something that this audience will well appreciate and is found in much case law. It's that the forensic approach to legal challenges is to be deprecated. The Court of Appeal referred to the usual authorities, Clark Holmes, South Somerset, but it again expressed its concern in paragraph 45 of the judgment, finishing by saying it's not a proper approach to judicial review, let alone an appeal. The fifth takeaway, public law takeaway, is that challenges based on a deficit of evidence will face an uphill task. And that's because the sufficiency of evidence is a matter for the judgment of the decision maker, subject, of course, to Wednesbury unreasonableness. And so at paragraph 43 of the judgment, I can leave you to read what is said there. But it's a reminder that where the challenge goes to something that is really in the province of a judgment for the decision maker, the courts will leave it well alone. The sixth takeaway is that appeals to the Court of Appeal are to be on points of law, and the judge observed that the appellant had made copious references in the Court of Appeal to the screening opinion and decision, but never once to the judgment below. And so summed up the position in paragraph 39 to say, on an appeal, it is incumbent upon an appellant to demonstrate that the judge erred in law in reaching such a conclusion. With that, I want to just look at 4 EIA takeaways. The first of which is the test to be applied at the screening stage is whether the development is likely to have significant effects. And the judge here reaffirmed the test in Loader, and I've highlighted there what the test is. Is the project likely to have significant effects on the environment? Only if there's a manifest error of assessment will the courts intervene. Next is about sufficiency of information and the question of whether there is sufficient information to issue a screening opinion and whether the proposed development is likely to have significant effects are matters for the decision maker. These cases of Birchall Gardens and Evans emphasise the paramount importance of the judgment of the decision maker. And the Court of Appeal made it clear that the courts impute a level of expertise and local knowledge to the decision maker and won't seek to go behind that or adversely infer a lack of such knowledge. The next interesting point that the case raised was in relation to the precautionary principle, which is found in recital 2 of the EIA directive. And the appellant submitted that there was an inevitable uncertainty about the air pollution created by the proposed development, and that the decision maker and the judge failed to have proper regard to the precautionary principle. The Court of Appeal said that was misconceived. The precautionary principle will only apply where there is a reasonable doubt in the mind of the primary decision maker. So merely because somebody else has taken a different view to the primary decision maker, it cannot be said there was no reasonable doubt. The Secretary of State, the decision maker, had no doubt. And the judge went on to consider where the precautionary principle might apply at the screening stage. And he said there were really 3 eventualities that could come to fruition. Firstly, the decision maker decides that an EIA is necessary. Secondly, that it's not necessary. Or thirdly, they may not know. And it's only in that third situation that the precautionary principle applies. Then lastly, the nature of screening decisions. The Court of Appeal emphasised the limited nature and scope of screening opinions. It said that a screening opinion is not intended to involve a detailed assessment of factors relevant to the grant of planning permission, that comes later, nor does it involve a full assessment of any identifiable environmental effects. It involves only a decision, almost inevitably on the basis of less than complete information as to whether EIA needs to be undertaken at all. And so as a result, the court shouldn't impose too high a burden on planning authorities in relation to what is the procedural stage. It is, after all, only a screening opinion. And it's for that reason that, as Esther covered, reasons for a screening opinion can be stated shortly. Now with that, I just want to take 2 minutes to touch on the Repsol case. It was a decision in the first tier general regulatory chamber environment that I was involved in. And I wanted to refer to it because it's a neat introduction to the EU ETS trading scheme. And that scheme touches upon a lot of what we are interested in as environmental lawyers. And you've actually seen examples of that in the talks already given today. Both Ned and Merrow mentioned the EU ETS scheme. And indeed, it did come up in the Drax case, as Ned mentioned, firstly as an example of a regulatory mechanism acting as a wider control over development, and also in relation to the duplication of monitoring requirements under the relevant EIA regulations. It's an international greenhouse gas emissions trading system, but the regulation around it is complex. And it's one of those things where you just have to put a towel over your head and get down and grapple with the detail. When you do that exercise, the scheme isn't as complicated as it initially seems. Operators are required to produce annual emissions reports that are verified independently. And then they hold an account with the EU Union Registry, which provides them with access to their allowances. Most sectors get a provision of free allowances, which diminish year by year. The power sector doesn't. At the end of each compliance year, operators must give up from their account one allowance for each tonne of verified carbon dioxide or equivalent emitted. And so operators must have sufficient allowances to cover their emissions, and allowances can be traded to make up for any shortfall. Now, as to the Repsol case itself, the appeal concerned a notice of recovery of allowances, and Repsol operated an offshore installation known as the Bleo Holm, which is a floating production, storage and offloading unit in the North Sea, and that is an image of it on the screen. Part of it broke in 2013 and Repsol didn't fix it. The effect was that their entitlement to allowances should have been reduced, but because they didn't report it, they carried on receiving allowances on the basis of a fully operational unit. The Secretary of State sought the recovery of that over-allocation. Meanwhile, the European Commission, in the context of Brexit, issued a decision under which they suspended allocations of the 2018 allocations to the UK, or allowances to the UK. And so Repsol didn't get its 2018 free allowances that it was expected. And it wanted to net off the over-allocation to the under-allocation for 2018. And it said the failure of the Secretary of State to do so was unlawful. The case was dismissed, Secretary of State won. It won on the basis of statutory construction, because on review of the legislative provision, the Secretary of State simply didn't have power to net off. But it also reflected the structure of the trading scheme, in which the EC has the power to issue allowances and not member states, and only the member states can recover them. So what's happening to the trading system now? Well, we're still a full participant in transition. What comes after is currently up for debate, but the government has said it's committed to carbon pricing as an effective tool towards meeting net zero. And it states that any future system will be just as ambitious as the EU ETS. It issued a consultation on it last year, but the response is still awaited. And so with that, I'm going to hand over to Andrew to talk about Stansted.
Good afternoon, everybody. Well, when this lockdown ends and the sun stops shining in this country, we will all presumably want to head off back abroad for our holidays. And when we do so, we may well find ourselves travelling through Stansted Airport. And we will perhaps be travelling on the new taxiway and using the new aircraft stands which are proposed at Stansted. And this intended expansion has led to an extremely important, I think, recent case focusing upon the ability of the Secretary of State to give an instruction that a scheme for development be treated as a nationally significant infrastructure project in circumstances where it does not meet the usual thresholds for inclusion within the NSIP regime in the Planning Act 2008. And the Stansted case was a challenge to a decision of the Secretary of State. In this case, the relevant Secretary of State being the Secretary of State for Transport. A challenge to that Secretary of State's decision not to regard the intended expansion of Stansted as an NSIP. Now, the two grounds upon which the challenge was advanced was, first of all, that the scheme in fact qualified within the NSIP criteria, and that the Secretary of State had wrongly concluded that it didn't so qualify. And then there was a challenge, if that challenge failed, there was then a challenge on the basis that the Secretary of State ought to have exercised his jurisdiction to regard the matter as an NSIP and therefore consider it through the DCO process rather than as a planning application made to the relevant local planning authority. Now, the scheme was for the creation of 2 taxiways and 9 new aircraft stands. And rather importantly, it didn't involve any alteration of the runway itself, Stansted being a single runway airport, and it did not. And it was the third phase of a 3-stage expansion project, and we'll see that that was of some importance in the eventual decision. The application was made to the local planning authority, Uttlesford UDC, and the pressure group Stop Stansted Expansion said that it ought to be determined as an NSIP. They first of all took their complaint to the Secretary of State for Communities, Housing and Local Government, who said, well, this isn't a matter for me, it's a matter for the Secretary of State for Transport. The matter was taken to the Secretary of State for Transport, who then refused to treat the matter as an NSIP, either by the automatic qualification or by exercising his discretion under Section 35 of the Planning Act. So that was really the background to the litigation. The nature of the planning application was that it would increase the million passengers per annum, which is the relevant measure for airport usage, from 35 million passengers per annum to 43. So with even my maths tells me that that is an increase of 8 million. Now, within the Planning Act 2008, Section 23, which is one of that list of sections which sets out in detail what the NSIP thresholds are, there are effectively 2 routes for consideration. The first is where the permitted level of passenger activity increases by 10 million passengers per annum. Now, that was never in play in this case because the application was simply not for that degree of increase. But the other issue, and the issue which is important in the litigation, is that the 2008 Act provides that if the facilities are capable, and that's the statutory phrase, capable of providing that increase of 10 million passengers per annum, then the scheme is to be treated as an NSIP with the consequences that follow, which we'll talk about a bit in a moment. So the first ground of the argument focused on this issue of what capable actually means, whether on the one hand it means what the new infrastructure would theoretically and hypothetically be capable of accommodating, or what the actual realistic and likely usage of the infrastructure would be. There was an additional issue of statutory construction as to whether or not the taxiways formed part of a runway, the runway being the phrase which is focused on in the legislation. But that was pretty quickly determined on the basis that they were part of the runway for those statutory purposes. So the issue really focused upon this issue of capability and what was meant by capable. And it was concluded that there were really 2 matters in which this could be challenged as a public law matter. The first was on the basis of the fundamental nature upon which the judgment had been arrived at, the issue of whether it was theoretical and hypothetical or against the actual likely reality, those 2 alternatives. And then the second was, as it were, the good old-fashioned public law basis of whether or not in coming to that judgment, the Secretary of State had regard to considerations which were not material, or failed to have regard to considerations which were material. Now, it was said, the first thing that Mr. Justice Dove, who gave judgment in this case, the first thing he said was that the issue of capability was a judgment call for the Secretary of State, which could only be interfered with on Wednesbury grounds. It wasn't a matter where there was a specific legal test which could be applied. It was a matter of judgment for the Secretary of State. And there's quite a long passage in the judgment where, beginning with the case of Mott many years ago, the judge went through in some detail the cases which pointed out the difficulty of challenging planning judgments, particularly where those planning judgments had been identified and based upon expert evidence, modelling, and those sorts of things with which the court was peculiarly ill-equipped to wrestle at the judicial review stage. Now that's, as Mark has commented on through the Kenyan cases, is fairly well established and obvious public law points. What's of real importance in this case is the conclusion that was arrived at, that the decision was not based on the theoretical or hypothetical capability of the infrastructure being provided, but, quote, an analysis based on how the infrastructure is likely to perform. Now, we'll look at the implications of that in a minute in the wider context of infrastructure and environmental considerations, but that was the fundamental decision. It's paragraph 101 of the judgment for those who want to read on later. Another important aspect of the decision was that it was said by the Stop Stands Today Expansion Group that the Secretary of State had failed to have regard to the possibility of night flights increasing as the additional capacity was given to the airport in terms of these new taxiways, new aircraft stands. And it was said that he'd failed to have regard to a material consideration, namely the possibility of those restrictions being lifted, and therefore there being more flights and therefore more passenger usage, and therefore it tipping into the NSIP category. The judge concluded that there wasn't any real evidence that night flight restrictions would be lifted, and so although there was a theoretical possibility of that happening, he had not erred in law by failing to have regard to that possibility when there wasn't any evidence to support it. The second ground is also of some considerable importance. It's the first time, I think, that the issue of the Secretary of State's discretion under Section 35 of the Planning Act 2008 has been litigated. Now, just a little bit of background. The section gives the Secretary of State a discretion to give a direction for development to be treated as an NSIP, for which you need development consent and can't apply for planning permission. That's a jurisdictional matter. But there's a discretion to give that direction if the project is within specified fields, unsurprisingly, energy, transport, waste, etc., classic infrastructure territory. And the Secretary of State thinks the project is of national significance. There is some guidance on this. It's not actually particularly easy to find, but if you ferret around on the NSIP website, it is there. Guides from 2013, setting out a range of factors which the Secretary of State has to consider, but the basic point being he'll consider all relevant matters. So there's a very wide discretion, and it's important to note that any person interested can apply for a project to be treated as an NSIP. So it was no bar to the Stansted litigation that it wasn't the developer who wanted the matter to be treated as an NSIP, but instead a protester who fundamentally wanted to stop the scheme. Anyway, these are the factors the Secretary of State is required to consider, and there is also to be consideration of whether or not the project would benefit in terms of the convenience of securing the necessary consent from being treated as an NSIP. And it's then finally concluded that the project has to be of a reasonable size, because something of fairly small scale is unlikely to come close to meeting any of the criteria. Now, the importance of all this, particularly within the environmental context, can be summarized, I think, in the following slide. The first thing is that often environmental lawyers are concerned with the ability to stop a scheme in its tracks because of the perceived environmental harm that it will do. And one of the usual approaches is to consider the need for the project. And in a planning application scenario, that's a perfectly legitimate and appropriate approach. But in NSIP cases, the need case is very often established by the national policy statements and indeed associated other national documents, which set out that there is a particular need for certain types of infrastructure. And if a project is brought by Section 35 within the NSIP regime, those national policy statements are automatically the starting point for consideration, and one can't, except in limited circumstances, go behind them. That's obviously very different to the planning application situation. It's also the case that the policies established in the NPSs are often favourable to large schemes in different ways. For example, within the energy context of EN1, the overarching policy statement on energy, there is, for example, favourable references to the fact that energy infrastructure, by its very nature, often is big and prominent in a landscape and has visual effects. And effectively, the policy says sometimes one has to just accept those as a necessary price for having the infrastructure. That isn't something which normally forms part of the policy regime considered for planning applications. So again, that works very much in favour of development for those seeking to raise environmental concerns and can make the position more challenging. Similarly, there's one consent given and one decision maker, and therefore the requirement, with all the pitfalls that it can have, to seek a variety of consents from a variety of different decision makers is removed in the NSIP regime. There's also an ability for associated infrastructure to be considered. So again, one application can consider a whole range of projects, and that may lessen the scope for environmental problems to be brought to bear to stop a development which is perceived to be environmentally harmful. I put with a question mark the fact that one finds from experience that obviously an NSIP being bigger and generally more high profile, it tends to get more direct and more engaged responses from statutory undertakers and from statutory bodies, which again can work to the disadvantage sometimes of freestanding challenges on environmental grounds. And there's a final bonus for developers that the timings for most of the NSIP process are quite firmly established, with the 6-month examination period, the 3-month report writing, the 3-month decision taking. Those are the reasons why this decision as to which way the scheme should be considered can be of some considerable importance for environmental lawyers. And then this is how the court, in the light of all that, looked at matters. The judge concluded, and it was a matter really of agreement between the parties, that there was a broad discretion in the Secretary of State, and at paragraph 102, the judge concludes that the task of the claimants is daunting. It's to be noted that this was a rolled up hearing, and so this was not a challenge which got through the permission stage. This was a one-stop shop approach to this particular case, and it's quite arguable in the way that the case was found that the case would not have got permission if it had simply proceeded through the normal route. A couple of particular points that were made. One of the grounds of challenge to the discretion was that the Secretary of State had failed to have regard to a material consideration, in that he'd failed to appreciate that the project was part of a larger project, sort of undisclosed intention to expand the airport even further. And the claimants pointed to certain references in meetings which had referred to a figure of 50 million passengers per annum, which obviously was considerably in excess of what the application was for, and would have taken the scheme well above the NSIP threshold. The conclusion there was, first of all, the facts didn't really bear out the conclusion, and also, as Mark has mentioned in his discussion on Kenyon, that the alleged facts about these meetings weren't even known to the Secretary of State at the time he made his decision, and therefore it really is surprising that the court concluded that he hadn't erred in that regard. It was also suggested that the implications of carbon emissions were a national matter, which ought properly to have taken the scheme into the NSIP category and required consideration on a national basis as an NSIP. What the court concluded there was that, and this is an illustration perhaps of the some of the benefits and pitfalls of the NSIP regime, was that those matters of carbon consideration had already been dealt with in national policy documents. There's a document called Making Best Use, referring to the need to make best use of the existing runways before contemplating building the third runway at Heathrow. But that document said effectively that the carbon emissions which would be generated by making best use of runways, in this case by adding those couple of additional taxiways, would not be sufficient to justify a refusal of consent. By extension, they weren't sufficient to require that the scheme be considered as an NSIP. And then finally, the protesters suggested that the economic effects were national, and therefore the scheme ought to be considered as a national scheme, and the Secretary of State had erred in law in not considering that. And the judge concluded that there wasn't sufficient economic evidence that the effects were any more than regional, and so forth. Therefore that was dismissed. Now the takeaways, to use that lovely phrase, first of all, the reaffirmation, Mark's again touched on this through Kenyon, of the difficulty of challenging judgments, especially where they are expert driven or based on modelling. This issue of what infrastructure is capable of. Now, it seems to me that this is quite important for wider issues other than just airports, because it's quite often the case that a facility will have a possible or a theoretical capacity which isn't in fact likely to be used the way that the operator actually intends and wants to operate his scheme. And therefore, the fact that the court now says the focus is on an actual analysis of how the infrastructure is likely to be used is actually pretty important for any ongoing debates where the size and capabilities of a facility is close to the boundary of whether it is or isn't an NSIP. And so that issue, that very clear steer in the judgment about what capability means, and I think that will be carried over into the other forms of statutory phrasing which relate to deployable output, other ways in which it's expressed for different types of infrastructure, is likely to be quite important going forward in determining whether schemes are launched as NSIPs or by way of planning applications, and that issue, as the court said, is a matter of judgment for the Secretary of State, with all the associated difficulties of challenging that judgment. With respect to the ability to discard possible changes if they're not likely, that all again flows from the fact that the issue of whether or not something is capable of having an effect is a matter for the judgment of the Secretary of State. So he can discard things if he in fact thinks they're not really very likely to happen. The emphasis on the broad nature of the discretion, spoken about that was clear. The judge used that phrase, a daunting task for anyone seeking to challenge it. And then finally, the ability for the Secretary of State in coming to those conclusions that he can properly and lawfully rely on other matters which have already been decided by national policy in coming to that decision about whether or not something is an NSIP or goes by way of planning application. All of which, in conclusion, I think has some considerable importance for the way in which environmental lawyers can try and seek to manipulate procedure in order to give their clients the best chance of getting the result they want. So I think very much an important case, and we'll see it taken forward in future litigation. So I think that concludes my presentation, all our presentations, and I think now we move back to James's chairmanship for the Q&A session.
That's great. Thank you very much, everyone. I don't think there is a virtual applause function on the on Zoom, but very grateful. I'm sure everyone is to have had your contributions. Thank you. Now, I'm very pleased to say we have 2 questions. So if I could invite all the speakers to turn their cameras back on, but not their microphones. Thank you. Thank you. So we've got 2 questions, and I'm going to read each one out before it's answered. And Merrow and Ned will be taking the lead on answering them. So I'm going to read them both out because Merrow is going to answer the first one, Ned's going to add something to it and then answer the second one. So I'll read them both out in one go and then hand over, okay? So the first one concerns the Whitehaven case, and the question is about production substitution and how that argument can be proven. In other words, I suppose, what kind of evidence or materials needed to establish the production substitution point. The second one concerns air quality, and not so much air quality under the Air Quality Directive, but its implications for the Habitats Directive, and in particular how Brexit may affect that. So I'm going to hand over to Merrow and Ned. I'm glad to say we've got a third question that's come in as well, so when you've finished, we'll do the third question.
Thanks, James. If I just jump in, this is in relation to the Whitehaven question. It might be useful just to set out that how we got to that argument really, and this is ongoing litigation. There's a limit of what I can really say, but this is a mine where most of the coal being produced is coking coal, which is going to be used for steel making purposes. There is a sizable byproduct from the application that's going to be what's called middlings coal, industrial coal, and that's not necessarily going to be used for the steel making industry. The applicant had argued from the get-go really that there was going to actually be emission savings from import substitution of this coal, particularly the coking coal, because we're importing in the UK and in Europe that from further afield, so that by producing it domestically, there will be savings in emissions from reducing the shipping of coal from further abroad. Now, interestingly, in the original officer's report for the council, the officer said, I've had regard to that. That's a saving of emissions, and I'm giving moderate weight to that. And that has to be balanced against the emissions of actually operating this coal mine, and I'm giving moderate weight to that as well. And that was what was highlighted on behalf of the claimant was that, and on interested parties, was that there had been no assessment of the emissions of the mine. So how can you be making that assessment where you don't know how you're comparing things? And it was after that point was flagged that the council then said, well, they had an addendum report, they took it back to committee, and they said, actually, we really are saying that the operation of the mine will be broadly carbon neutral on the basis of that production substitution point. So that's where we are now. I just thought it might be useful to set out a bit of the background there, but I think Ned's going to jump in as well on this.
Can I just jump in at this point as well? Sorry to cut across you. This was an argument that came up quite a lot in what I regard as the good old days when I used to do cases promoting open cast coal sites, where we tended to run exactly the same argument, that the coal that we would be producing indigenously would substitute on a ton for ton basis with imported coal. And one was able to do a relatively easy, albeit broad brush calculation of the emissions involved in the respective transport regime. So from Russia or Australia or whatever by rail and then by ship. And that could be compared with the carbon output of transporting the coal from its domestic production site to wherever it was intended to be used. With coking coal, it was relatively straightforward because there were only a limited number of end users, and therefore the likely destination one could calculate, and indeed the sites that could, from where it could come abroad, were again relatively easy to identify, and you could do a calculation, which we succeeded in persuading a number of inspectors was a relevant consideration to which some significant weight could be given, albeit that it was broad brush, and of course there were there were plenty of ways of poking holes in the final number, but the magnitude of the savings tended to be so great that it was a factor worth having. And that worked very well as long as the level of imported coal was higher than total domestic production, because then the one-for-one substitution argument for cost and other reasons tended to be fairly robust. And as to the emissions from the respective mining operations, the point was effectively taken that the coal had to be mined somewhere, and that the emissions would occur one way or another, whether they occurred in the UK or whether they occurred in Russia or Australia. It didn't really affect the overall carbon calculation, because the CO2 would go into the air wherever it was produced. And inspectors tended to regard that as something which they would allow to go by effectively as washing one from the other, and the focus would be on the transport calculation. And of course, we always had a sneaky suggestion that our environmental standards were a good deal higher than would be observed in a number of the places where the imported coal would be produced. And so that tended to work quite well. And so I'm glad to hear that line of argument, which is a well-worn furrow, is alive and kicking to the day. So sorry to interrupt the participants, but those are my thoughts from some experience.
No, I think I would just add on top of that, though, that point about the scale of the import versus what's being used domestically, and in this case, there is exporting of the coal is envisioned as well. So that's quite an interesting point as well. But I probably will pause there. Certainly, I can just say that it is part of the claimant's case that is not, the evidence is not there.
Yeah.
For production substitution, but I think I'll pause there.
I mean, if one would think, if it's relatively easy to do this calculation, that a criticism that Merrow's clients might make is, where is the calculation if it's so easy? I think what's nice about this question is actually the difficulty, the imponderability of market substitution arguments. And it may be that in a different context, when you're looking at security and supply, it's simpler. But my feeling is that when it comes to climate change, it's much more difficult. It's just a hugely complex equation as to what's going to happen if you get coal out here. And the other reason I like the question is because on one view, market substitution is something that you can see an English or Welsh UK domestic court saying, oh, that's just planning judgment. They gave weight to it. Is it relevant? They gave weight to it. That's enough. And that outweighs the other impacts. And that they may well be the kind of arguments that Merrow has to meet in due course. But there's something harder edge to it as well. And it's interesting to look at some of the cases on coal extraction in America and Australia. There's this argument of market substitutions raised. I was looking at one, it's called Gloucester Resources Limited. It's a decision of last year from Australia, where the market substitution argument was raised and was rejected as essentially illogical. So what I'll do, rather than sort of quote that, I'll copy that case reference into the answer box. I'll try and be technologically savvy, so you can see that. But I think there is something to be said for the argument that it is simply illogical to rely upon something as vague and unproven as market substitution. Whether the English and Welsh courts have presented with such an argument would go as far as to say, well, that's just irrational. I don't know, but interesting to see where that goes. James, was I to respond briefly to the next question as well?
Yes.
Right. Well, the next one's a bigger kettle of fish, so I'll respond as briefly as I can. Lots of our environmental law comes from EU directives, essentially. There's two answers to this. As far as the language of the law is concerned, none of it's going to change for now. We will wait to see in due course, after the dust has settled, on what changes might be proposed. It's all open for change because we lose the hard backbone of European law, but the language of the law will remain the same. And there's a few bits and pieces where there's slight differences in wording, but I think in substance, it's pretty much all being copied over. But What we do lose is the European Commission, and this gets us onto a whole debate that I know many have been involved in about the Environment Bill, because whereas under the Climate Change Act, domestic legislation, you can see a coherent regime there. It has the reporting statement requirements to Parliament that are made. The Secretary of State can therefore be held to account because those reports go to Parliament. European law doesn't have that. European law, if we don't comply with it, we have to date been held to account by European Commission action that's taken against us. There's no equivalent provision where Parliament has some role which it could step into the shoes of the Commission and hold government to account. Of course it could, but we see the relative looseness of Parliament over the last year or so in all sorts of different contexts. So I think what we lose is that enforcement backbone that the European Commission gives us, and whether or not that's adequately replicated depends very much on how the Environment Bill goes forward. At the moment, the Environment Bill is proposing an Office for Environment Protection that won't do what the Commission does. I suppose it also depends on how Parliament responds to its new status. I think without rambling on for far longer, that's all I've got to say on that one.
Thank you. And we've got a third question, which arises, I think, from the last talk. And it's this: how can the Stansted approach to capability be reconciled with the approach in the environmental permitting regime, where references to capacity are to potential or design capacity and not the actual production levels? And I'm going to kick off by saying something about that, and then I'll hand over to Andrew, as it was his presentation. I've certainly done NSIP cases in the waste sphere where it's been capacity that's been the relevant matter, and objectors have said, but hang on a minute, that might be the design capacity, but that might not be the throughput. The throughput per year may not actually exceed the design capacity. And there the approach, in my experience, has been that it's design capacity that's relevant to get you over the threshold or not what's actually expected to happen. And that dovetails in with the environmental permitting regimes. That's the first point I'd make. I think the second point is it's important to bear in mind the actual wording of the statute, and I've just got up the wording in relation to airports, and in relation to increases in passenger movements, it talks about the effect. In other words, the effect of the proposal is expected to be. So I think the particular wording is important. I think the third thing is, if I've understood Stansted correctly, and I haven't read it in any detail, I think Stansted isn't it, a case where on the face of it, it wasn't above the NSIP threshold, but there was a question about whether it should have been judged to have been or directed to have been. And you can see in that circumstance where the design of it is not intended to be, but the function of it might be above the threshold. A slightly different approach might apply to where the design is intended to be and would be above the threshold, even if year on year the particular throughput of the NSIP might not be, because throughputs year on year can be very difficult to gauge, and also it's part of the actual examination process to figure out the merits and what might actually happen when the thing's built, and it's difficult to answer that as a threshold question. So those are my observations on that. Andrew, we're kind of up against time, so if you want to add anything briefly, and then I'll summarize. Thank you.
Sure. Just very briefly, I think the way one might look at it is that the environmental permitting regime is obviously for dealing with issues of environmental compliance and requirements and so forth, whereas the issue in the Stansted case, the NSIP approach, is simply through which route do you proceed to get your planning permission or your consent, including planning permission. And so it's not entirely surprising that there's a slightly different approach. Just dealing with the points that James made more generally, I agree. The interesting thing about the Stansted case is now that has been held so clearly, what the approach to capability should be within that section of the 2008 Act, whether there will be any spillover into the way things are considered in other aspects where the statutory language may not be quite so clear, but the principle may be applied. We'll see. Thank you, James.
Thank you. Good. Well, thank you everyone for attending. Just to round up, I hope you've enjoyed today. We've got a thriving program going forward. You can go on our website and find out about that. I think our next event is on Monday concerning development plans. Regular attendees will know we run these environmental briefings regularly. We have done so for some years, and we're going to be continuing to do so. So watch out for the next one. We'd welcome any suggestions you've got about how we might make them kind of more interactive on this platform while we're in lockdown. But in the meantime, thank you very much for your attendance, and I'll invite all of the speakers just to give it a wave goodbye, and wishing everyone who's online well. Look after yourselves. Thank you. Bye-bye.